Greetings, I'm Glenn Witecki from the Witecki Law Office in Schenectady, New York. I'd like to talk to you next about the probate process. Now, the probate process is a process by your will is submitted to the local surrogates court in the county in which you resided at your passing, and whereby the judge is responsible for determining that it was you that signed the will, that you had capacity to understand the will that you were signing, and that you properly declared it to be your will and asked your witnesses to sign it, and then asked them to sign affidavits attesting to the fact that they witnessed your will. Many folks think that when you sign a will and then pass away, that the will automatically gives authority to your executor to manage your estate, but that's not true. If you do a trust, your trust does not have to go through the court, and your successor trustee or your trustee does have authority to administer the assets in the trust without going to court. The same is not true of a will. For your will to have validity, then anyone who would have inherited if you didn't have a will has a right to challenge your will. And we've done a separate video on this site saying who can challenge your will, under what circumstances, and measures that you may take in order to avoid such challenges. But your executor needs to file the will with the court, get consents of people who have a right to challenge the will, that the will be admitted. If they don't consent, they can file objections and go through that process. But mostly the judge is concerned with, did you have capacity to sign it? Did you declare it to be your will? Was it properly witnessed? And the judge wants to make sure that you were not subject to coercion, duress, or undue influence when you executed the will. So we encourage you to look at other videos on this website that deal more specifically with those topics. Thank you.